This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about the right of a litigant to amend a pleading to avoid statutory immunity and why an insurer by statute is immune from suit for good faith reports to in this case, the Louisiana Department of Insurance of suspected fraud, and surprised that the appellate court gave the plaintiff a second chance to sue the insurer who reported suspected fraud. In Solon E. Smith versus the state of Louisiana and several insurers, the Court of Appeals of Louisiana on October 23, 2025, addressed whether an insurance company, CMFG Life Insurance Company, is immune from civil liability under Louisiana's insurance code for reporting suspected fraud to the Louisiana Department of Insurance, similar to statutes in various other states. On December 22, 2022, LDI issued a suspension order ordering Mr. Smith to cease and desist conducting any business of insurance in the state of Louisiana. On February 8, 2023, the Louisiana Department of Insurance issued the revocation order permanently revoking Mr. Smith's license to sell insurance and issuing a fine. On April 19, 2022, the suspension order and revocation order issued by LDI were reversed by the ALJ, as the ALJ determined the evidence does not support a finding that Mr. Smith violated the relevant statutes. Specifically, the ALJ determined that Mr. Smith, having made a typographical error on the application, is a much more probable explanation than the alleged fraud. On July 31, 2023, Smith filed a petition for damages against LDI CMFG, alleging defamation, malicious prosecution, abuse of process, and unfair trade practices. CMFG claimed no civil liability for good faith fraud reports, and the trial court sustained the exception and dismissed CMFG with prejudice. The relevant law starts with a peremptory exception of no cause of action, similar to a summary judgment or motion to dismiss. The statute tests the legal sufficiency of the petition and assumes all well-pleaded facts are true, but conclusory statements insufficient. For affirmative defenses like immunity, the exception will be overruled unless facts exclude all reasonable hypotheses supporting the defense. There is, in Louisiana and many other states, a mandatory fraud reporting statute where insurers and others in the insurance business must report suspected fraud to LDI's Office of Insurance Fraud within 60 days of notice. To convince insurers to comply, the statute also provides an immunity from liability for making a good faith report, and that no civil suit, such as defamation, torts, exists for required reports or information shared with the LDI or law enforcement unless malice, fraudulent intent, or bad faith exists. Plaintiff bears the burden to allege facts defeating immunity. Conclusory claims such as reckless disregard are insufficient. Analyzing the issues, the court noted that CMFG qualifies as a mandatory reporter because it is engaged in the business of insurance. The petition facts show that CMFG reported based on Broussard's credible affidavit her belief of fraud due to non-receipt of policy. There was no duty for CMFG to investigate further because the statute shifts that duty to the LDI. Immunity applies because there were no viable causes of action alleged. Now, the Court of Appeals affirmed the trial court's January 18, 2024 judgment insofar as it sustained CMFG's peremptory exception, raising the objection of no cause of action. However, it reversed the portion of the judgment dismissing CMFG from Mr. Smith's suit and remanded the matter to the trial court to allow Mr. Smith an opportunity to amend his petition with specific facts showing malice. The Court of Appeals concluded that the trial court abused its discretion by not allowing amendment of the petition. The decision balanced mandatory fraud reporting duties with protection against malicious reports, emphasizing that conclusory allegations alone cannot defeat immunity. Chief Justice McClendon dissented and concluded that there was no abuse of discretion because an amendment would be futile given facts of the case. The statute protects insurers from retaliatory suits for good faith compliance, but preserves the amendment right to prevent premature dismissal. In my opinion, the statute that requires an insurer to report suspected fraud to the LDI also includes immunity for the insurer's good faith report unless the insurer makes the report with malice. The decision on appeal gives the plaintiff the chance to amend his pleading, to find some way to sue the insurer that was not immunized. The Chief Justice's dissent is convincing, to me at least, since an amendment would be futile and defeat the purpose of the immunity statute by making the insurer defend for a second time through an appeal the futile attempt to allege fraud or malice with more than mere conclusory allegations. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 5,200 blog postings. Please tell your friends and colleagues about this blog so that they too can subscribe to the blog or these videos on YouTube and rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for very small fees subscribing to my Substack publications. Thank you for your attention.